Great. Well, thanks for helping set this up, Rod. Rod and I have been consulting with each other on cannabis issues in North Carolina for years now, I think, and we figured it was high time to collaborate on a project and share our areas of expertise. For those that don't know me, I'm Phil Dixon. I'm a faculty member at the UNC Chapel Hill School of Government. I'm the director of the Public Defense Education Team, and so I work on criminal law issues, and that's what's brought me to focus on a lot of cannabis issues. Rod, do you want to introduce yourself for anybody that may not be familiar with you?
Sure. Hey, everybody. I'm Rod Kight. I'm an attorney. I'm also based in North Carolina, and I'm a business law attorney. We represent businesses in the cannabis industry throughout the U.S. and the world, with obviously a big focus on North Carolina for a lot of reasons. And as Phil said, the two of us have been working together because there is an intersection of, unfortunately, still of cannabis criminal law and cannabis business law, and some of those things we're going to get into today. But Phil's been a great resource, and we've been talking for years, and I'm really excited to be talking about cannabis today.
Likewise. And just for the record, Rod and I are both licensed to practice law in North Carolina. I'm licensed as well in the Eastern District, the Eastern Federal District of North Carolina. You have a federal licensure as well, Rod?
I do. I'm licensed in North Carolina and Oregon, and right, I've also practiced law in the federal courts of North Carolina as well, Western District and the Fourth Circuit.
So we'll be talking about a mix of state and federal law, with Rod really having more expertise in the federal area, whereas I am better on the state criminal law stuff. We're not intending to give legal advice. We're just intending to have an informative conversation that we hope will stir thought and discussion among listeners. If you're interested in this topic, I encourage you to check out our respective websites and resources. Rod has an excellent website. It's constantly being updated with content. That's Kight on Cannabis. It is cannabusiness.law, just like it sounds. And there's a link to his blog and to podcasts and video episodes there. Encourage you to check that out. I'm a frequent reader. I always learn something about the regulatory and administrative law side of things. I am a regular blogger on the North Carolina Criminal Law blog. That's at nccriminallaw.sog.unc.edu. I talk about all kinds of criminal law issues, so do my co-authors on that blog, but a lot of my work is dedicated to cannabis, and I'll actually be putting out a two-part cannabis update for spring 2024 coming out real soon. I also do have a podcast devoted to North Carolina criminal law issues. That's the NC Criminal Debrief. I haven't been back in the studio to record an episode in a while, but I'll be back on that soon too. You can find the NC Criminal Debrief on Apple or Spotify, or just put it into Google and it should come right up. Any other resources I'm leaving out there, Rod?
I think that's great. Your resources are fantastic. As soon as I see one of your things pop up, I'm on it, just because. And I think, for North Carolina folks, for sure, but even just an analysis of criminal law and cannabis issues for people in general, just to understand the evolution and the arc of where things are moving. I think Phil's stuff is excellent.
Well, the feeling's mutual for sure. I know one thing that was on my mind, we talked about getting ready for this episode, and that I hear from a lot of folks out in the field is, what's going on with THCa? What is this? Is there one thing that we mean when we're talking about that? I've heard confusion from consumers of like, was this like CBD or Delta 8, where something sprayed onto hemp flower, or is this its own product? Can you tell us a little bit about what you know about THCA? Is it legal? How is it legal? Is it synthetic? Is this not? What can you tell? I know it's something you work a lot on.
Yeah, sure. So I would say that a majority of the calls we're getting right now happen to be about THCA. So I'll give a little sort of overview summary. THCA is tetrahydrocannabinolic acid. It is the form of THC that's actually most abundantly produced in the cannabis. And by cannabis, maybe I'll hit pause right there and say, when I use the term cannabis, and probably Phil as well, I'm talking about the plant. Under the law, there are two types of cannabis. One is marijuana, and the other is hemp. Marijuana is federally illegal and also illegal in the state of North Carolina. Hemp is federally legal, and it is legal in the state of North Carolina. And the sole distinction between the two is the concentration of delta 9 THC, which cannot be more than 0.3% if it's going to be legal hemp.
But
But
it's
when I
all
talk about
one
cannabis,
plant.
it's all one plant,
Biologically,
right?
we're all
There's
talking
not
about one plant, right?
exactly. So I'll use the term cannabis a lot, just generally, and just for people who are listening, I just want to be clear. I'm not talking about cannabis in the way that it's often referred to, meaning marijuana. And for the people who get upset at the term marijuana, listen, I get it, but that's the term that the law uses, and so that's the term that I'm going to use because I'm a lawyer, and we need to be very clear about these things. So back to the THCa, it's tetrahydrocannabinolic acid. It's the most abundantly produced cannabinoid in the cannabis plant. It is not in and of itself psychoactive. So if you were to, maybe some people have, eat a cannabis bud, you're not likely to feel intoxicated. That's because most of the THC in it is THCa. Its legal status so it's not synthetic. It's not something that's sprayed on. And the two forms that we're seeing THCa in the market are in the flowers and buds, and also in what's called an isolate, or maybe in a concentrate. To give a little overview of the legal status, THCa, and I'm going to refer to the flower now because it's easiest to talk about that, and then I can just kind of have a little side note about the other stuff. It is legal under federal law, and it's legal under the laws of North Carolina, meaning that it's not a controlled substance. Now, and that's because flower with high concentrations of THCa, but delta 9 within the 0.3% limit, meets the legal definition of hemp. Now, when I tell that to people, very often their first response is, no, Rod, listen, you missed something. If you look in the Farm Bill and also the USDA rule, it's very clear that you have to test using what's called a post-decarboxylation method, which refers to what's sort of known in the industry as total THC. And total THC is the concentration of delta 9 plus 0.877% of the THCa in the sample. That's the molar sum of the two, to use a little bit more of a mathematical term. And there's a reason for that, and that is because when heated or exposed to light, or even due to time, THCa will convert in a process called decarboxylation into delta 9. And so to go back to the statute, what the Farm Bill and the USDA is referring to is really the total potential delta 9 THC. And those people are exactly right. Excuse me, I got a little bit of a cough. In all 50 states, in order for a hemp grower to harvest his or her hemp crop, that grower has to pass this post-decarboxylation total THC test. If the total THC is more than 0.3%, the farmer is going to have to destroy the crop, or some states allow remediation. That's kind of beyond the scope of today's call. But that's it. However, once that test is passed, that hemp crop can be harvested. And at that point, all of the required testing has been accomplished. And then we're in the zone of the statute. And what's the statutory definition of hemp? Well, it relates to delta 9, and it doesn't refer to a post-decarboxylation test or anything else. And that's the case under federal law. It's also the case under North Carolina law and the laws of some, but not all states. And this is highly confusing for a lot of people. It also raises some issues that we're going to talk about regarding testing and so on and so forth. But harvested cannabis material with delta 9 levels not more than 0.3%, but with high THCa levels, is in fact lawful hemp. One more thing, and then I'll move on, and that has to do with those isolates I was talking about. The DEA released a position statement about a year ago, almost a year ago, stating that THCa was in fact a controlled substance. It actually fell under the tetrahydrocannabinols line in the Controlled Substances Act, and it went on to say that that THCa is a controlled substance because, according to the Farm Bill and the USDA, in order to test, you have to use this post-decarboxylation method. And so I wrote a blog article on that, and I said, well, the DEA is part right and part wrong. You do have to use that post-decarboxylation method if you're talking about a pre-harvest sample. But again, once that sample has been tested and approved, that plant can be harvested. And so that test that the DEA refers to doesn't apply. And so THCa that is from hemp is not a controlled substance. But, buyer beware, so to speak. The DEA holds a different position. And so I think it's really important for people to understand that.
And so to be clear, when we're talking about flower THC, you mean somebody has grown a plant, they've got a
Mhm,
strain where the Delta 9 THC in the organic form is within the legal limit, but it's got a
mhm.
high concentration of THCA that can then just be flowered, cured, harvested, cured, and then, ingested by people. That's how it's out there. And that's in contrast to things like Delta 8, right, where they've
Mhm.
taken hemp, turned it into CBD, and then extracted an isomer like Delta 8 or Delta 10 from the CBD. Do I have that right?
Yeah, no, that's exactly right. The cannabis plant naturally produces delta 8, but it's in such minuscule quantities, at least with the current cultivars, that you can't extract it and make it economically viable or commercially viable. So right, so they extract CBD, which is itself hemp under the definition, and then you derive delta 8 from it, which is a pretty straightforward chemical process called isomerization. But that also qualifies as legal hemp, although it's again a pretty controversial topic. But you've been working on this. Tell me, what distinguishes synthetic cannabinoids from like hemp cannabinoids and things that we don't have a definition of.
Well, that's interesting. It's a particularly confusing under our state criminal law because we recognize a whole category of substances that have nothing to do with marijuana called that we call synthetic cannabinoids. This is your stuff like spice or K2 that was popular on the market really before the advent of legal hemp. And it's not something I see a lot of anymore. There were, this stuff was all over the gas stations, convenience stores, smoke shops, maybe 7 years ago or so. But one, we crack down on it. We have specific, like for instance, drug trafficking laws that target these synthetic cannabinoids. But when we talk about synthetic cannabinoids in this context, we are talking about things that mimic cannabinoids, but they are not cannabinoids. They are not naturally occurring in cannabis plant. They are not derived from the cannabis plant. And separately, our law says that any synthetic THCs, tetrahydrocannabinols, are illegal. And when we talk about synthetic THCs, well, it's really not clear what we mean there
Mhm.
either. But presumably, that's distinct from this category. It's a whole huge category of like 9 big different chemical compounds with tons of variations on them that we classify as quote unquote synthetic cannabinoids. Then we have, this separate category of synthetic THCs. And we just simply don't have guidance on what that means. I have written in the past and have speculated that when we talk about synthetic THCs, we're talking about creating it out of whole cloth in a lab, like not deriving it from a plant. Because I think that's the most natural reading when you look at the federal definition of hemp and now the state definition of hemp as of a couple years ago. It includes not only the plant material, like you discussed, that's within the legal limit and sourced from hemp, but it includes all extracts, derivatives, isomers. And presumably, when I, take a hemp product, take hemp in its organic, plant-based form, and derive, THC concentration, say something like Delta 8 THC, um, from it, that is still, I've not converted it magically into a synthetic product, although it has undergone a process of synthesis on some level. So we don't have any guidance on that, and I don't honestly expect to see a whole lot of guidance on that anytime soon. But it is worth noting, North Carolina criminal law refers to both synthetic cannabinoids as something wholly unrelated and separately bans synthetic THC, which it recognizes as sort of related to marijuana. But all it says is we don't have a definition of what synthetic THC is. We don't know where the line is. When does the process of synthesis, qualify something as synthetic THC? And is that in fact a whole, made out of whole cloth in a lab from other compounds, or would it count just by simply concentrating a THC product? And again, my interpretation, I think the best, most natural reading of the law is that, if these extracts and derivatives are permissible, then surely the process of creating them from the plant does not render them an illegal synthetic. But open question, really. As something we'll get to later on. Rod and I both are well aware. there's a real lack of regulation all around here. Are you seeing other things with synthetics? I know you touched on it briefly. Um, I think we talked about, was it THCO or P that is a synthetic?
Yeah, THCO. And so I think where, at least on the controlled substances level, I think where things seem to fall naturally is something that you raised, Phil, and that is, does the cannabis plant, hemp plant in particular, produce this cannabinoid naturally? And so, to go back to the Delta 8 example, the cannabis plant does produce it. It can be produced naturally. Now, what's on the market is a synthetic version, meaning it's just been converted from CBD to Delta 8. But that's not a controlled substance because it falls within that definition of a derivative, of hemp. On the other hand, THCO is not a compound that the cannabis plant has ever produced, and it is a form of THC. It's a cannabinoid that still shares a similar structure. And so I actually reached out to the DEA because it was a really popular cannabinoid for a while and was used in a lot of these blends. And a client wanted to send it overseas, and I was like, well, the very threshold question before we even get to whether this thing is legal in the other country is, can we get it out of the country, which requires that it be legal under US law. And I saw kind of both arguments on it, and I thought, well, just ask the DEA. Not that the DEA is always right. I just brought up a situation in which the DEA was actually wrong, but it was good to get that guidance. And the DEA came back and said, no, THCO is a controlled substance because it's a tetrahydrocannabinol. It's a synthetic form of it that's not produced naturally. And I think, you got to give the DEA credit when it deserves the credit. I think it was right. A lot of people were very upset with that decision, understandably, but to me, that drew what I thought was an appropriate line in the sand. And so then you have a question
Between
about,
something that naturally arises in the plant
yeah,
versus something that is created and derived from the plant but does not occur in nature.
that's exactly right. And so you have questions about THCP, tetrahydrocannabiforol, and HHC, and some of these things that we don't see as much. Those are actually technically produced by the plant. There is some evidence that they are, but they're even just very, very minuscule quantities. And that really takes us to sort of, I think, another question, which is, well, if these are not controlled substances, is it okay to sell and market them? And this is where we get into, I think, a really touchy issue. Let's say, for instance, we've got, well, let's just go back to Delta 8. It seems to be the easiest one because it's people tend to know Delta 8, and it's also got a history. So the Delta 8 molecule itself has been studied now for decades. In fact, one of the primary studies is an Israeli clinical trial of using Delta 8 on children who were undergoing chemotherapy. And it's actually a wonderful study to read. It was done by Dr. Meshulam, who's sort of the grandfather of cannabinoid research. And I think every single child had some benefit, and none of them had any downsides. And if you talk to scientists, they'll say actually Delta 8 is a very stable compound. And so Delta 8 itself seems to be safe. The problem with Delta 8 and Delta 8 products is the process by which they're made is not very regulated. So you could get a very well-made Delta 8 product, and that's no problem at all. But you could also get a product that, in the process of converting it from CBD to Delta 8, maybe produced an offshoot of other cannabinoids or other chemicals. You tend to use one method of doing the conversion is to use an acid as a reagent or a catalyst. And for the scientists out there, I apologize. I'm just talking in general terms, but some of those reagents or acids could be left behind and they can be harmful. So it's really the process. And I think that's where we really need some regulation. And I think the focus has been on, these cannabinoids like Delta 8. Delta 8's dangerous. Delta 8 shouldn't be distributed. But that's not necessarily the case. It's really more about the process. But on the other hand, there are some of these cannabinoids that are produced naturally by the plant that haven't been studied. And so I think some people like to think, well, we've been consuming cannabis for thousands of years. No one has ever died. It's a safe plant. And I think that in and of itself, makes sense. But what about these compounds that occur in such small concentrations naturally, but that now we're concentrating and using them as the dominant active ingredient in these consumer products? And I think that's where we start to run into some concerns. And I tell clients, there's this whole thing like, just because you can, maybe you shouldn't, or maybe you should do some some testing or and pull in before you start promoting these products. So while I am a big proponent of strict interpretation of statutes like the Farm Bill, I will absolutely defend the fact that these a lot of these sort of more esoteric cannabinoids are not controlled substances when the cannabis plant naturally produces them. I also am very hesitant to recommend that just because you can do it, you should. So I
Yeah,
think
there's sort of this ethical concern underpinning it, right? If we don't know, then caution is advised.
yeah. And what are you seeing? I mean, how are you seeing other states? I know that you focus on North Carolina, but you also follow trends along other states with some of these synthetic cannabinoids, or
I
whether they are from hemp or not.
Well, I mean, I'm just, I'm just sort of tickled listening to you rattle these off. And that's what I've seen. I mean, I was in Atlanta recently. I just walked into a gas station, but like many gas stations, they have a bunch of hemp products for sale. And I saw a vape pen that was labeled as containing Delta 7, Delta 8, Delta 10, HHC, and THCM. The M was a completely new one to me. I mean, I really do try to stay on top of these trends. I try to know what's going on with the new products, but it seems like every time I go into one of these stores, I'm seeing a new, THC something that I've never heard of before. So I think your observation is spot on. That yeah, I mean, what I think you referred to it as an alphabet soup, right?
Mhm. Yeah, it
Um,
seems like it is an alphabet soup, and I the gas stations and convenience stores get the bad rap. I don't think that convenience stores are necessarily a bad outlet for cannabinoid hemp products, because convenience stores sell all sorts of regulated products, from tobacco to nicotine to alcohol. But I think it's also tends to be where you see some of these more the alphabet soup of products, and I think it's sort of chasing a novelty, and I don't really support that piece of it. Again, maybe we'll learn that some alphabet soup cannabinoid is actually safe, but we don't know necessarily now, and I think it's important to not run that train down when there are plenty of cannabinoids that we know are safe, and in different formulations that we do know are safe. So speaking of that, what about some of these trademark claims that we're seeing? They're not necessarily specific to cannabis, hemp, but have to do with some of the using a famous brand to sell other types of products.
Sure. That is one of the, that is maybe the most common kind of regulatory crackdown that I'm aware of in North Carolina that's happened. And my sense is it's typically the alcohol ALE, the Alcohol Law Enforcement Division, who comes into these stores and takes a look, and where somebody has a hemp gummy product that's labeled noids, let's say, and it's marketed in a way that looks a lot like a box of nerds, like the candy. um, they will seize that product as in violation of the intellectual property owner's trademark, and in some instances bring actual criminal charges. We actually do have a criminal penalty attached to trademark infringement in North Carolina. And my sense is it's not being done a lot, and it varies, just like marijuana enforcement in the state right now. It varies a lot from jurisdiction to jurisdiction, and sometimes even within jurisdictions. It may depend on whether you're in the city, or whether subject to the local police, or whether you're out in the county subject to the jurisdiction of the sheriff. But that really, the times I have seen and heard about hemp store owners and retailers getting into trouble or crossing paths with the law, there have been a very limited number of instances where law enforcement has obtained these products, obtained a hemp product, actually gone and done the proper testing, which is not something they typically do in marijuana prosecutions, and then determine that it's over the Delta 9 limit. And then come back and say, we think all your products are contraband, or we know this many of them, or this brand that you're selling, we're going to consider that to be contraband because we tested it, it's over the Delta 9 limit, and potentially try and charge the person. The other, and I'll come back to that in just a second, but the other way, and I think more commonly, is these seizures based on alleged trademark violations. That is really it. I mean, I did recently read of one store where it looked like they were basically selling marijuana products, But in several cases where there have been raids of hemp stores for alleged, hot products with
Mhm.
exceeding the Delta 9 THC limitation, they're over, but they're not over by a lot. They're not over to the extent like you would see in a normal marijuana product that you might
Mhm.
see, from Colorado or a legal state. And you sort of referred to that earlier in talking about deoxycarbylation, if I have that right.
Uh, yeah, decarboxylation, right? Exactly. It's a strange
Decarboxylation.
word, yeah.
Because that's it. These products might be at 1% delta 9
Mhm.
THC or 2.1% delta 9 THC. And it occurs to me, depending on environmental factors, depending on how long it's been on the shelf, depending on what it went through in processing and distribution, that could just be the result of the natural process occurring where other cannabinoids have now shifted. And I know too that that's a potential problem with the testing. You referred to the testing of total THC, and my understanding is that depending on the test that's used to measure THC levels, they can actually convert what would otherwise not count as Delta 9 into Delta 9 by way of the testing process
Mhm.
itself. Are you familiar with that phenomenon, Rod?
Oh, yeah, that's that's something we're seeing all the time, and I think this is where your particular layer, of expertise and mine sort of really connect, and that's the testing stuff. And we'll talk in a minute. I want to hear. I know you've done quite a big breakdown on reasonable suspicion and probable cause, but before we get to that, let's talk about the testing. So used to be, when there wasn't hemp and everything that was cannabis was illegal marijuana, that the tests just needed to determine whether or not THC was present. And so just about any sort of reasonable test would work. But that's not the case anymore, because now we have, the difference is the distinction between one form of THC, and again, it's a percentage of that relative to the weight. So the tests have to be specific, but they also can't convert another compound to the one that they're actually measuring. And so to get more specific, we're talking about THCa and decarboxylation. So let's say we have a hypothetical. Hypothetical is we've got a cannabis bud, and it's got 0.2% delta 9 THC, and it's got let's just make up a number, 20% THCa. And let's just say for our purposes, we know for a fact that it was grown by a lawful hemp grower. It passed the pre-harvest certification. It was harvested lawfully. And then we know that these values, the 0.2% delta 9 and the 20% THC, are accurate values. Well, that under federal law and the laws of North Carolina is a legal hemp bud. But guess what? If you smoke it, you're going to get high. And if you, it's going to look and smell exactly like marijuana. So law enforcement, let's say they get a hold of this for whatever reason, a pullover at a traffic stop, or they did a controlled buy in a store, or there was a warrant and they collected a bunch of it from a store or whatever, and they test it. They're going to test it using a post decarboxylation method. Out on the street, they're going to use a DL. I can never pronounce the name. It's a two person name, a Duquesne's Lenoir or something like that. A field test, and that they're
The
going to drop
Regent
it in a
test, so, right? Yeah.
the Regent test, yeah. So they're going to put it in a little baggie. They're going to create a chemical reaction. It's going to turn a certain color if it's marijuana. Well, that reaction actually converts the THCa to delta 9, so it's going to pop hot. It's going to pop as if it's marijuana. And then even in the crime lab, where we've got expensive or expensive laboratory equipment, they're going to test it using a method called gas chromatography, and probably with mass spectrometry or fire ionization. But the main point is they're going to test it using a method that heats the sample. And this is not a bad method for testing lots of different types of botanical things. What happens at a certain temperature, different compounds, different molecules will elute. They'll be released at a certain rate, and so you can measure them. And it's a very common, very well accepted practice and type of laboratory measurement. It just doesn't work to distinguish between hemp and marijuana, because the heat is sufficient to convert that THCa to delta 9. It creates that decarboxylation. So this, to kind of go back to our example, the 0.2% delta 9, 20% THCa flower is going to come back after a gas chromatography test as something having like 15 to 18% delta 9 THC. Law enforcement is going to say, oh, yep, this is marijuana. We knew it. And the
And it's going to take
problem
a pretty savvy defense lawyer who's on top of all these issues to even recognize that that's a potential issue, or to
Yep,
know, hey, I need to bring in an expert, retest it ourselves, and be able to present science to combat this, faulty test that's being presented in court as gospel.
that's exactly right. And so I'm trying to get the word out so criminal lawyers, even if they don't understand it, at least know that there's an issue there. And then I'd love to be able to have them combat it. There are scientific experts, lab people that can be called in as experts. But then we also have to make sure that we are educating the prosecutor, the jury, the judge correctly. These could get into some pretty technical issues. So people, will often say to me, so THCA is legal, so I'm good to go, right? And I say, hey, wait a second. The THCA flower is legal, but it is highly risky. And it's highly risky because this is novel to the law. We don't have a whole lot of case law on this. And we also are assuming that the people that are going to be listening to this in a trial, hypothetical trial scenario, are going to be taking it all in and processing all of this properly to show that this is the wrong test. There is a proper test. It's called high pressure liquid chromatography, which does not heat the sample up. It just pushes the compounds through, and they elute at different rates based on this material that's in a tube. Again, I won't go too deep into that, but that test is not typically being used for criminal cases. And I think that sort of brings us into have you seen anything with the testing piece, but also what are you seeing, Phil, on with respect to hemp and like reasonable suspicion and probable cause, and where's the state, where's the case law going with all of that?
Oh, it's such a mess. I mean, just to stick with testing for 1 second. I mean, for what it's worth, as I think you're aware, neither our state crime lab nor any law enforcement crime lab anywhere in the state is capable of testing Delta 9 THC levels. They don't have the ability to test that. So
That's an important
when this
statement.
stuff right, it is, and it's shocking, but it's true. Our crime lab lacks the state crime lab lacks the capacity and ability to test for specific levels of Delta 9 THC. They are nonetheless churning out reports that say we tested this, we detected the presence of Delta 9 THC, and in our opinion, this is marijuana. They will acknowledge under questioning on the stand that, well, yes, it's true. Hemp is legal, and we didn't test the level, so we can't be sure if it's hemp or not. And that is, you would think this, however many years into hemp legalization, perhaps the law enforcement labs would have caught up to this, but they have not. So what you get in a criminal case as far as testing goes, I mean, in many cases, they don't bother with a lab at all because one's traditionally not been required. And the state of the law currently is that an officer's lay opinion, just his, I saw it, I smelled it, I'm trained, I know what it looks like, I think it's marijuana. That's sufficient to send the case to the jury and to potentially convict somebody if again, there's not a savvy, well-informed, well-equipped defense lawyer standing in the way. But assuming you do get a lab report, you get this fairly, I think it's fair to call it misleading lab report that identifies something as marijuana without actually distinguishing it from hemp. Now, that said, when they are really animated, say you've got 100 pounds they found in a tractor trailer and they want to get the guy for trafficking, good DAs, good prosecutors know that lab's not going to do. The official, crime lab's not going to do. It's not going to be enough. And they send it to private labs that are capable of doing the testing. But those can be black boxes in terms of their testing procedures, their policies. And yeah, are they using the liquid chromatography method or are they using mass spec GS? You may not know that, or it may not be obvious. And many attorneys were not scientists. We went to law. We did not go to law school because we were great at chemistry for the most part. And if you're not really on top of these issues, it's easy for something to get snuck past you. We saw this in a recent high-profile case. It was covered by All Things Considered out of Charlotte, where a woman was smoking what she claimed was a THCA joint. Obtained from the store, nearby, outside by a bus stop, and it ended in a violent encounter between her and the police. And in the wake of that, the local crime lab, the local Charlotte Mecklenburg Police Crime Lab, released a lab report that said, we tested it, we found the presence of Delta 9 THC, and therefore it's marijuana. And then there's a little asterisk at the bottom of the report in fine print that says, well, hemp is also legal under the Farm Bill, and we didn't test to distinguish, whether it's hemp or not, so we can't be sure. So I don't know what the value of that kind of report is. And then, frankly, I was surprised to see that disclosure, because that was the first time I'd seen it acknowledged on the lab report. Many times that's only going to come up in cross-examination of the analyst on the stand. So the testing issue is hot. I don't encourage anyone to plead guilty to alleged marijuana offense. And there's resources like me, or Sarah Olson is the Forensic Resource Counsel with Indigent Defense Services of North Carolina. She has a website, forensicresources.org. And we're able to help you with issues like that might come up in your case. So that's one, is this big gaping hole of a problem with testing in the labs. On the PC, and sorry, let me try to not speak in legalese. I think many people know you need probable cause, enough facts and circumstances for a reasonable person to think a crime's being committed and this person did it. You need probable cause to arrest somebody, to seize their property, or to get a search warrant to do those things. And our courts have now for a couple of years been acknowledging, traditionally the odor or sight of suspected marijuana is probable cause all day. Probable cause to seize it, to arrest the person. That's enough. Since the advent of hemp, defense attorneys have been strenuously arguing that rule doesn't make sense anymore. It can no longer be considered, valid. The rationale for it has fallen apart because there's now this legal product several tons of legal products that look and smell identical. So we've seen the courts say, hey, this may be a problem. We recognize that our law on the odor and sight of marijuana as probable cause may need to be revisited. But again and again and again, they have said, but not in this case. Here the defendant admitted it was marijuana, or he acknowledged he smoked a blunt, or he said his friend may have smoked something. And, courts have struggled with it. The argument is it's really, you need odor or sight plus something more. And we see trial courts applying that standard. And we see, I get a bird's eye view of what's going on in the state. And I know for a fact that many judges will suppress evidence, as in, keep it out, keep the DA from being able to use it, when it's based on the odor or sight of marijuana only. But when it gets up to the appellate courts, the closest they've come to dealing with it is to say, maybe an issue, but here there was plus, and so we're not going to decide the question yet. So it's a live issue for defenders to argue. I will say, reviewing the case law, and again, I'm about to put out a piece that's going to go over some of the recent case law. That plus, to the extent that is the rule, it's not a whole lot of plus. It might just be extreme nervousness, or, like I said, an admission. I think certainly signs of intoxication might get you there. Many times the courts have said, the defendant did not raise the issue of it being hemp, which I think, a little bit turns the standard on its head,
Right.
putting the burden on the defendant. But, we don't have a clear answer. And you might not know that depending on which cases you read, because in several of these cases, they've said, we're not deciding the issue. The issue is still open. But by the way, the legalization of hemp changed nothing about the Fourth Amendment law, changed nothing about our search and seizure rules. And so there's, in a way, there's this doublespeak, which one is it? I think those comments, like nothing has changed, tend to be what we lawyers would call dicta. It's not part of the essential holding of the case. It's just sort of extra commentary that the court is throwing out there, because when they expressly say, we're not deciding this issue, I don't think anything they say after that purports to decide that issue matters from a strict legal standpoint. But of course, that's not how opinions get used in court. And when there is this harmful language that, hemp changed nothing, the odor inside of marijuana is still enough, that's what ends up getting quoted to the courts, and then by further, court opinions. So the probable cause issue is live. We did recently get an answer about reasonable suspicion. Now, that's an even lower standard than probable cause. It's just sort of like, are there some facts that would justify investigating? So that's what you need to just detain somebody and briefly investigate them. So think about what's called a Terry stop. I'm going to just stop and ask you what you're doing. Why are you here? What's going on? See if I can figure out, are my suspicions correct, or have you, dispelled my suspicions? And I thought for a long time that the odor of sight of marijuana would probably still count as reasonable suspicion. So you take that Charlotte example I just gave you about the THCA joint. If they see someone smoking what looks like a joint, it smells like a joint, is an officer entitled to approach that person and say, hey, I need to ask you about that. Where'd you get that? What are you doing? I tend to think that kind of brief investigatory detention is permissible. And we recently had a case from the Court of Appeals that basically said, yes, when the standard is reasonable suspicion, that's even lesser of a standard than probable cause. And it's going to justify a brief temporary investigative detention, or in this case, it was extending what was otherwise a traffic stop, to investigate a traffic violation, smelled marijuana, began investigating that. And the defendant complained, hey, you got off track. You were immediately doing a drug investigation. And they said, no, the officer had a reasonable suspicion of marijuana possession. So it's a fine line that I think is really only applicable to practitioners for the most part. But we don't have an answer on probable cause. Sounds like we do have an answer on reasonable suspicion. But of course, all of these cases are extremely fact specific. They all, in every case, it's a matter of looking at all the circumstances, the totality of the situation. And so there's always room to argue depending on what your facts are. But I think that's the message I'm getting. We've also had cases about canine sniffs. They seem very reluctant to, say that these dogs hitting on a car, that they're just trained, the canines are just trained to detect THC. So they alert on both hemp and marijuana. The courts have seemed reluctant to give that up or to acknowledge that, and they've acknowledged it as a potential problem. We don't yet have a case saying, this is going to be a problem here. In two of the cases, they weren't looking for marijuana and they didn't find marijuana, where they found marijuana alongside other more serious drugs like meth or heroin. And they've said, well, that's not really relevant. This whole issue of, is the dog reacting to THC or not? So we still don't have a square answer on the canine sniffs, but again, I think sort of an uphill battle for defenders trying to challenge these canine sniff. It's a totality question. It can be done. But the hot topic for me is drug ID. And we sort of touched on that with talking about lab reports. But again, as I mentioned, officers are entitled to give a lay opinion that, yeah, this is marijuana. Well, that's hardly a helpful opinion when there's not any testing, given the state of things. Even if you bring in an expert to say, I checked it under a microscope and I've looked at the chemical signs of it without a lab test quantifying the levels of delta-9 THC, that's not a reliable expert opinion. And then, as we said, those lab reports may or may not actually be reliable. And if you really want to get nerdy, there's a sort of another sub issue here. The Supreme Court of the United States is about to decide a case called Smith v. Arizona that deals with this practice of using a substitute analyst. So someone does the testing, someone generates a lab report, but some other person comes in at trial and says, I've reviewed this lab report, and I think, yeah, in my independent opinion, it is marijuana based on this lab report. But it's my independent opinion. I'm not using this lab report because that would be a confrontation clause problem. We permit this in North Carolina, and this comes up when they do the testing with a private lab. It's in my anecdotal sense is the person who does the testing at the private lab is usually not the person who comes and testifies at trial. Or there was 10 people involved in the testing of the product, but they send one person to trial and try to get it in under this theory of substitute analyst testimony. That practice, it looks to me, is going to be struck down or severely curtailed by the U.S. Supreme Court. I've counted it up, and I'm pretty sure there's 5 justices that are going to vote to strike this down in Smith v. Arizona. I've blogged about that, I think, last December. And I just want to put it on any criminal defense people's radars that, even if you get past the probable cause, the reasonable suspicion, the opinion evidence, even if they get a proper lab test, there may still be an issue not only with the testing process, but how that lab test gets presented to the trial court. So, a very rich area. I started trying to write my spring 2024 cannabis update and realized this is going to have to be a 2-parter. We'll hit the probable cause, reasonable suspicion, and canine issues in part 1. part two is going to go over these drug ID and opinion evidence issues, along with stuff like, the federal reclassification efforts that are underway, and the fact that now there's recreational marijuana within the koala boundary of the Eastern Band of Cherokee Indians.
Yeah. Well, I
So
can't wait to
lots of
read
stuff.
that.
Yeah, lots of stuff to talk about. And I will say, just for anybody who's not going to follow up on the reading, that last bit is a real interesting thing because for non-Indians, like Rod and I, for instance, we are welcome to go on the koala boundary and purchase legal marijuana as of April 20th. That is when they are opening the doors of their dispensary. But state and local civilian, as in like non-tribal law enforcement, have concurrent jurisdiction over non-Indians in that area. So as soon as we're in possession of marijuana in the koala boundary, we are also violating state law and are subject to arrest and prosecution by non-tribal authorities. Now, is that going to happen? Or, is the sheriff's office going to stake out the dispensary and look for, non-Indians to enforce the state marijuana prohibition on? I don't know. I think that raises a lot of political questions that are probably beyond the scope of our expertise. But that's going to be something very interesting to watch. And I could go on, as you know, Rod, but I'd say just check out the blog when it comes out next week, or at least part one should come out next week. And I'm always happy to talk to folks who want to talk to me more about it. But I wanted to ask you, at least in our last few minutes, about the FDA regs. I know there's
Yeah, sure.
we have this broad guidance about can't put it in food for humans or animals,
Right,
no
right.
medicinal claims, no marketing as a dietary supplement. But I see bags of gummies labeled not a food. I mean, is that all it takes to get around this, or is it just a lack of enforcement, or what's going on with that? 'Cause, I mean, edibles are ubiquitous. I mean,
They are. Well, let's put a pin in that for one second, because this subject of probable cause and reasonable suspicion is so important. I just want to have a quick follow up.
sure.
On the canine piece, as I understand it, and I could be wrong, that I think they're hitting on terpenes, but in any event, they're not, in order to have, it seems to me, probable cause, and we're talking about not the presence of, but the concentration of an odorless, colorless, molecule. It seems, and also to your point about the officer just being able to inspect it. I mean, no one can see a THCA hemp flower and a marijuana flower and make a distinction. Even people in the industry think they can. Oh, I know, but the fact is, a very well done cured THCA bud is going to look exactly like a well done cured marijuana bud. But the question I have before we jump in the FDA piece is, so let's say someone has, hemp in their car and they know it's hemp, and they are stopped, and law enforcement says, hey, can I search your car? Just as a general, and we're not giving legal advice here, but as a general matter, should people consent to a search, or should generally people say, this is hemp, but I'm not going to allow you to search, in order to preserve this argument about probable cause? From a practical matter, is there some sort of best practices might be a way to think about this?
Well, look, I mean, you know me. I was a career criminal defense lawyer, and my job now is to train defenders. No one should ever agree to a search. No one should ever agree to take any tests. No one should ever agree to give any statements. It's none of that is designed to help you, the person who's under
Right.
suspicion. But there is this practical element too of, like, if it is hemp and you have a receipt from the hemp store, and you're not carrying any contraband, does it make sense to say, no, you can't search, but I'm happy to show you my receipt. This is a legal product. That's what you're smelling. And if we had that case, say that person gets prosecuted for marijuana possession or other drugs, but it stemmed from the odor of marijuana that was squarely, provably from a legal hemp product, I think that presents a much different set of facts for the, for the courts to grapple with. Again, never admit anything to law enforcement, just as a general rule. I mean, that's your right, and you can waive that right. And police, to their credit, I think, many are good, well-intentioned, and trying to police in good faith, but they certainly depend on that. And, often you don't have to just refuse consent once. You might have to refuse consent 3 or 4 or 5 times before they really get the message. And if law enforcement is going to search you, there's nothing you can do about that at the end of the day. But you don't help them make their case by agreeing to it, because you've effectively waived any search and seizure, any Fourth
Hmm.
Amendment protections. I don't think you waive the hemp marijuana argument. I mean, that can always be
Right,
litigated at suppression or on the merits at the trial. That's where that has to be raised, or it will be waived for appeal. But
right.
on the roadside, I mean, there's sort of common sense determinations that you have to make. General rule, I don't tell anybody to volunteer information or to any more than you have to. I mean, you have to show your license. It might make
Right.
sense to say, yes, I'm traveling from this place to this place. But getting into, more detail than that, I think people should exercise their right to remain silent. They should exercise their right to refuse searches and pat downs. You don't have to agree to that stuff. You don't have to agree to take field sobriety tests. Now that can be a factor against you if the officer is trying to establish probable cause. And while we're on it, those field sobriety tests are made for alcohol. They actually don't detect
Right.
marijuana impairment, but often officers will try to use them to detect marijuana impairment.
Mhm.
So I mean, there's just more issues here than I can shake a stick at.
There are.
And
Yeah, the driving, the impairment issue is a whole different thing. How do we test for that when someone could have smoked, some cannabis of whatever stripe, a week before, but it's in their system and they're clearly not intoxicated at all. Whereas sometimes people might have just ingested a gummy but it's not, but
hmm,
and they're just coming on and they're highly intoxicated, but it wouldn't show up on a test if they haven't. I mean, so the way that we do impairment testing for driving is as it has to be, substantially different from the way we do it, for alcohol. And I don't think that that's caught on yet, but it's a whole entirely different topic. And I think we hadn't planned on talking about that. So
I
we'll
got to say one more thing, Rod.
yeah,
Not
man.
only do we have, sometimes people, you said people in the industry, certainly officers sometimes get up on the stand and say, no, I can tell the difference between hemp and marijuana. I've looked at them and I can just tell. We've had cases where officers have testified under oath that they can smell the difference in THC levels between hemp and marijuana. And
That is
again, this is
insanity
a
to
scientific
me. Wow.
impossibility that is ludicrous. But when a deputy is sworn, gets up there and says that they may truly actually believe that,
Right.
it comes in and it counts against the defendant unless the defense attorney is ready to object,
Hmm.
keep it out, preserve the evidence challenges. And depending on where you are, there may not be, great attorneys, or there may not be attorneys that are well versed on this issue. And in that case, in fact, there
Right.
was no objection to that testimony.
Oh,
The defense lawyer just let it come in and then complained on appeal, but it's too late at that point. So, if you're a defense lawyer watching this stuff, you gotta be ready for your objections. Object on grounds that something is an improper lay opinion or an improper expert opinion or an unreliable opinion. And even if you lose that in front of the judge, you can still argue it to the jury that you shouldn't give it any weight because of these ambiguities around it and the uncertainties. But I think that's it. Did you want to weigh in on the FDA question a little bit?
yeah, we'll chat about the FDA for a minute, and I think it also has some it means something in North Carolina as well. So just broadly speaking, the FDA has taken the position. It's long held this position that you cannot add CBD or THC to food, and you can't market it as a dietary supplement. And a lot of people hear that and think, wait a second. To your point, I see THC and CBD gummies everywhere. They're on, Amazon for that matter. Well, how in the world can that be true? Well, what it's based on is something called the drug exclusion rule that effectively says that if there's what they call an article, it means a molecule, a compound, an ingredient of some sort that has not been um, previously, or I'm so sorry to say, has been the subject of clinical test trials before it was used in food or marketed as a dietary supplement, then it can't later be used as food or dietary supplement. And the FDA says, well, both CBD and THC were the subject of clinical trials for drugs before they were in food. And therefore, the drug
Oh, so because
exclusion rule
because like
prohibits it.
Marinol and what's the
Correct.
CBD one, Epidiolex or something?
Epidiolex, yeah. Mhm.
Yeah,
And
have been
so
they've gone through clinical testing, so they sort of get a carve out here. That's how
they get a
that's how
carve
that
out
works.
there.
Cool.
Yeah, and so yeah, right. The FDA is wrong. I actually testified about this to the FDA, because they're sort of giving an overgeneralization, and I could geek out for just a second, but then we'll kind of pull back out and talk about the practical implications. It has to be the exact same moiety, which means that the drug has to be a very specific compound, that was tested under very specific conditions, certain concentrations or milligrams into this population and this formulation, blah blah blah. And Epidiolex and Marinol and some of these others, Dronabinol, were not the same as what we see in most cannabis, and I'm talking about that broadly, but certainly hemp products, which are mostly made from an extract that contains multiple cannabinoids and terpenes and phytocannabinoids and sesquiterpenes and blah blah blah, a whole extract, and that's not the same moiety as what was happening in Epidiolex. Additionally, you can go back
Which
and
is effectively concentrated CBD, right? And
highly
Marinol is sort
refined.
of concentrated delta 9 THC, which is
Yeah,
why
it's a
my
synthetic
understanding
form.
it never caught on because it didn't actually produce the same effects as marijuana.
That's exactly right.
A full spectrum product with all
Full
those
spectrum
compounds you
product.
rattled off. Yeah.
Yeah, no, you're exactly right. And I think that these are pharmaceutical drug products, and they should be highly purified. I mean, these are pharmaceutical drugs, highly purified, but that's not what we're seeing in the market. And so I think A, that FDA is just wrong in its interpretation. B, if you look back, going all the way back to the Civil War, you can find, it's really cool to look at. You can find advertisements for cannabis oils and tinctures and things that people were taking 100 years before the test trials for Epidiolex or Dronabinol or
Wow.
whatnot. So to say that they weren't in the food group at the time is crazy. All of that being said, the FDA has stepped back and said we cannot and we're not going to regulate these products, which has allowed the proliferation of the CBD and the THC edibles market, with one specific exception, and that has to do with people that are making or companies that are making health and medical claims about these
Hmm.
products. So the FDA has enforced in the way of cease and desist letters and warning letters and so on and so forth about companies. So outrageously, you'll see companies that are promoting like this CBD product can help with hair loss, Alzheimer's, and cancer, or something like that. But even things that seem pretty innocuous, like sleep or stress or whatever, those are actually medical conditions, and that's a violation. And a couple of things that I think shake up some people when they think about it. One is if there is a customer review of your product that raises a health issue, that's imputed to you. So let's say you have a social
Oh,
media
wow.
site, and a customer says, you're not making any claims, but a customer says, I love your product. My child takes it for seizures and is recovering one or is doing wonderfully. Thank you. You've saved our lives, and we appreciate you. Well, the FDA will say, well, since you control that platform, you are effectively marketing your products as a drug to help with seizures. And the FDA has been really stern about that. So that's one thing.
So
The other
retailers
thing
have to
that
just go in and remove that kind of comment if it
they
pops up
do,
on their website. They have to know the rule and then also sort of self-police that way.
they have to. That's exactly right. Now, if it's a platform you don't control, well, then you can't self-police. That's okay. But the other thing is, well, I have clients that will say, "Hey, man, look, I've got a clinical study right here. It shows that CBD or THC or whatever actually helps with this." And in fact, there is, I'm the legal advisor to a cannabis medical journal, and there are lots of things that these cannabinoids can help with. But the fact that what you're saying is maybe true and even supported by clinical evidence is irrelevant. You just cannot market your products, because if you market them as having a health or medical benefit, then the FDA says, well, you're marketing them as a drug, and this is an unapproved drug. You haven't gone through the phase one,
The
two, so on,
FDA drug approval process, right?
approval process. So
Yeah.
what we're looking at now as an industry is a way to say, well, how do we deal with this? The FDA says we cannot, and we're not going to regulate these things. But in addition to, on the one hand, it creating sort of an opening of sorts, it also creates an obstacle of sorts too, because everyone who's marketing these products is, at least in the FDA's eyes, doing so illegally, even though they're not enforcing it. And that doesn't work in a broad market. And so we're looking at things like a monograph model. A monograph is a classification system for different botanicals and what they've done and what they can do and toxicities and things like that. So a monograph model is something that we've advocated for. I say we, some groups that I work with and a lobbyist named Tammy Wall. She's done a great job promoting that. But there are other pathways as well that we can consider, and it is an obstacle that the industry as a whole is going to have to get past. And whether it's setting up some other agency to regulate cannabis products, whether it's using a monograph model, whether it's some sort of litigation or statutory changes to this drug exclusionary rule, we don't know, but that's going to have to be a path forward. Bringing it home to, so to speak, to North Carolina. North Carolina has pretty much adopted wholesale the FDA's approach in terms of the North Carolina Department of Agriculture. It agrees with the FDA, but so much so that it's not really enforcing it either. But we have from time to time had the Department of Agriculture come out and make some position statements itself. It has also done some audits of folks. So beware that is out there, and it's something for companies to fold into whatever they're doing in terms of their strategic plans moving forward.
That's
So,
fascinating stuff, Rob.
yeah.
Um,
So what else?
well, we're hitting an hour. I think that's probably
Yeah.
good for today. I think if anything, we've learned that we can talk about this stuff all day, and we probably should
Yep.
do another one of these soon.
I'd love it.
But
That sounds great.
just to remind folks, Rod Kight is a industry lawyer working within the hemp field. He's at cannabusiness.law. You can find his blog and podcast there. I blog about criminal laws generally and cannabis specifically on the North Carolina Criminal Law blog. That's nscriminallaw.sog.unc.edu. And I have a podcast as well, the NC Criminal Debrief, that you can find where you listen to podcasts. Anything in closing, Rod?
No, thank you, Phil. You are a wealth of information, and you're like a beacon of light out there in terms of these things. Sometimes I feel like, I'm blogging and I'm talking, and I'm wondering if I'm being heard, or if I'm, and then you'll come in with one of your blogs where you break it down, sometimes with some case law, and it's like, oh, this is great. It's just validation that we're on the right path here with hemp. And so I have no doubt that 10 years from now, certainly 20 years from now, we will be looking back and this is sort of a chaotic time where all this law and all these things are emerging, and they will have solidified, probably in some good ways and some bad ways, but at least we'll have case law, we'll have best practices. Hopefully the FDA issue will be resolved, and so on and so forth. And I really just appreciate all the incredible work that you're doing. And for the criminal lawyers out there that are hearing this and they're thinking, oh my gosh, this is there still is, unfortunately, a cannabis law criminal practice, please connect with Phil. Please read his blogs, because these are super important issues that need to be addressed and addressed properly. So yeah,
Well,
this has
thanks,
been
Rod.
fun. I look forward to
Yeah,
doing
this
it
has been a
again.
blast. I've learned something. It's always a pleasure talking to you. I mean, again, the feeling's totally mutual. For those of you who are out there working in the hemp industry or interested in it, or want to know more about this regulatory stuff, I don't know of a better resource out there than Rod and his website. So real pleasure, Rod. I hope we get to do it again. I don't think we have any shortage of information to
Right.
cover. So I'll follow back up with you soon about that. And again, I'll be putting something out on this soon, and I'm quite sure if we can get this ready before then, I'll have this episode linked in that blog piece as well. So thanks again for listening. Thanks, Rod, for having me. I'll talk to you soon, I hope.
Talk soon. Thanks.
Take care.